Hi, welcome to this video. My name is Rob Cartmel at ProTrust Consulting, and we're specialists in estate planning and the administration of estates and trusts. And this is a video to deal with aspects of estate planning and to provide a little case study of a typical scenario where estate planning is required and where our sort of expertise and specialization is generally called upon. So I hope this next 10 to 15 minutes will be helpful and useful as a guide in that area. So what is estate planning? And you'll hear this phrase estate planning being used more and more, I think, as the years go on, with various aspects being more understood and popularized, not just limiting, therefore, to matters of wills, lasting powers of attorney, which are the typical areas of estate planning. Wills often contain trusts for the protection of estates, and that very much comes into the foreground of other areas that people are often asking us to look out for them, such as inheritance tax planning and the maximization of the estate passing to family members on death and in the most efficient way. So inheritance tax planning and estate protection go very much hand in hand, and protecting estate from erosion and claim from outside influences. And 2 or 3 of those are mentioned there on that slide. So when we're looking at estate planning, we are looking at all of those areas together, along with some other facets of that might not be dealt with by ourselves, such as areas that financial advisors might deal with, or lawyers, in terms of perhaps inheritance tax products and other areas that we might be able to give some guidance on as part of what we do, and then can introduce you to people who can help in those areas. But primarily our areas at ProTrust Consulting are dealing with wills and trusts, the preparing of lasting powers of attorney, and then it's to do with planning and protection. And we take a lot of detail from families of their financial circumstances. So I'll show you this page again in a second, and family circumstances. And that's really important. It's good due diligence, it's good practice, and it's the right thing to do when you're taking instructions about people leaving their assets and how best to pass them. We need to understand the circumstances of not only the people we're taking instructions from, but the people to whom those assets are going to pass. So that is quite a lot of detail that we will need to take at the earliest possible stage, so at our first 1 or 2 meetings. So this is just a little case study of some of those scenarios that are frequently before us, and sort of commonplace, I suppose, in our firm for the sort of clients that we act for. So this is just a typical example for a married couple. So we often act for lots of other people, individuals and people who aren't married and cohabiting, etc. So just take this as a sort of case in point here, with a married couple owning a property and they have savings and investments. So their main estate might be, say, just over £1 million. And in this case, as a lot of cases, they will own the property jointly, but they're not quite sure how that's held, whether they might have heard of the phrases joint tenants and tenants in common, but they're not sure what they mean. They're not sure whether their property is one or other of those. And in this example, they've got a significant amount of monies in pensions, and they haven't drawn any of them. So they've given me this kind of information, and we need to kind of work out what is applicable to their estates. Similarly, they might have an investment that a financial advisor has suggested is placed with a particular provider that provides business relief investments. So that's an inheritance tax planning product where they hope to keep the control of those assets of £100,000 in that example, but that after 2 years of owning them, they fall outside of their estate for inheritance tax. So that's what they tell us in this example, with the whole estate being worth £1.5 million. Now, in the family circumstances, this particular example is a married couple with 3 children. The married couple are in their 70s, so they've gone into retirement age in this example. and they've got 3 adult children who all have young children, but they're now young adults. One of the grandchildren is getting divorced. Oh no, sorry, the children. One of the children's getting divorced. The other 2, one is married and one is with partner. So immediately we see that sort of information of children being married. We're thinking about looking at protecting what passes to them so that a divorcee cannot attack that claim, that share of inheritance as easily, at least. And the couple concerned do not yet have LPAs, lasting power of attorney, but they know of them having acted as attorneys for their own parents. And that's a typical situation. And when did this couple decide to then do their own LPAs? So how would we approach that situation? I'll come back and just show you those details again in a minute, but we will only advise after taking a full sort of set of information on those situations and circumstances. Particularly in terms of wills, it's important to understand the manner of how they own the assets, as that can greatly affect whether a will covers such assets. So do you know that pensions, for example, and assets already held in trust, and joint property owned as joint tenants, so one survives the other in ownership in legal terms, those sort of areas, those sort of assets do not form part of estate passing through a will. So if we're advising about preparing a will, we need to understand this, and we need to have a good understanding of the assets and how they're owned. So in that standard case, as part of our taking of instructions and details, we would prepare a statement called an inheritance tax calculation spreadsheet that simply really is no more than a basic spreadsheet showing assets, liabilities, tax reliefs, and ultimately what assets in their estate pass through their wills to their chosen beneficiaries. So in that case, the spouse to each other and then to their children and down the line. So in that sense, once we've done that process, with that case study of asset base here, we would be suggesting will trusts, almost certainly, to protect that large value of 1.1 as it stands. Now, the pensions will be within their own trusts and outside of the estate. The 100 in business relief will be part of the parent's estate. So that would probably add in there and be 1.2. So if it was split equally, it'd be 600,000 each. So they want to protect their 600 to pass to the surviving spouse and then down to the children. And wills are individual documents. So each of a husband and wife needs to have that for own protection for their own share of the estate. So we will be, no doubt, advising on a will trust structure, which is a fairly complicated looking document to the layperson and even to the more educated in this area. So that with it comes a side document of explanation, a memorandum of wishes that will detail a lot of the important information as to how the spouse will physically inherit the first spouse's estate, but protected to pass down to the children, and how that structure works. And we spend quite a bit of time explaining that both before taking the instructions and then with some drafts. But these structures, these will trusts, are just standard approaches these days for many, many, many families across the country. They are just documents. They are simply set up to design to protect your wishes, but in successive interest terms. So to the spouse and then children, for example. But we will run through all those aspects. So a will trust structure would apply. And they also absolutely should have their LPAs done. In the event that either of the husband or wife loses capacity, you want people to be able to take decisions and act in their best interests. So they have 3 adult children. We have to have regard to perhaps any circumstances of influence from other in-laws, etc. But normal thing would be perhaps for the married couple to appoint each other and all 3 children jointly and severally to act as attorneys. So they should have that put in place. So that's a really whistle-stop tour of the basics of estate planning. So you've got will trusts, you've got lasting powers of attorney, and at the same time, as part of it, we're preparing an inheritance tax calculation position so that they can then take further advice on that going forward. And they have an understanding of what their estate really means in terms of the assets that pass through their wills to their family. So that's our role. And our role is to continue that and to educate them and the family going forward. And we'll set some parameters with you as to how often you might want them to review matters. So that's that approach. And this is our firm as a brief summary. So we are a legal background. We have a legal background, but we sit outside of the solicitors, accountants, and financial advisors, but work very much alongside those entities. And we are experts and specialists in this area of estate planning and continuing it with the administration of trusts and estates. So most of our clients, most of the people we act for are home counties based and increasingly London, as we have our office in London, our head office. We act for a full range of clients. They're not having to be that wealthy to want to still protect their estates for their chosen family. So we do not set out to act for certain clients and certain individuals. We are here to help you. And as part of that is educating then the people we act for and the family going forward, so that you are planning and not panicking as to how your estate is to be dealt with. And I hope that is a good summary for a short video like this, but please come and see us and we'll be happy to see you. Take care.